society like this to bring about harmony. But submission is nothing pernicious. It is consistent. Has been the Sarva Dharma Samanvaya that has always been maintained. And my Lord, your Lordships, may my Lord be pleased to dismiss the petition, my very humble and respectful submission. My Lord, for your kind patience.
Thank you.
Please, your Lordships. I beg to appear for respondent number 7 in the same writ petition. And with your Lordship's kind leave, I'd like to cover one aspect that Senior Mr. Naganand has left to me, which is the position in other jurisdictions as to the width of the freedom of religion and the approach of the European Court of Human Rights in the light of international conventions. I'll try to be very brief, my lords. All of it is covered in this very note of submissions. I'll request your lordships to please take the note of submissions. The lordships will be kind enough to come to page 12 and permit me to point out para 16 of the note. Page 12 of the note, bottom of the page, is para 16. May I point that out, my lords? Para 16. The width of freedom of religion differs from country to country depending on the constitutional provision in that regard. The First Amendment to the US Constitution and also Section 106 of the Commonwealth of Australia Act are almost similar in their language. Reference to Constitutional Law of India.
We'll go through this. We'll go.
Yes, my lord. I was only requesting your lordships to kindly permit me to read the first few lines. Learned Senior Counsel has read the latter portion of this paragraph. Kindly permit me to place that first portion, the sentence starting with again. Again, it is attractive at first blush to refer to American decisions on the First Amendment to the US Constitution.
We are totally on the constitutional issues.
That's right.
So so far as the width of the freedom of religion differs from country to country is concerned, you have already elaborated in your submissions.
That's right.
And that we will consider that.
That's right.
Right now that is not required.
The point that I was trying to make.
We are confined to the constitutional rights.
That's right. So therefore, my lords, certain decisions, American decisions, have been relied upon by learned counsel for the petitioners. And the point that I was trying to submit is that American decisions have no place in our constitutional system. And that's exactly what Mr. Silva has brought out in this particular paragraph. And my lords, as far as American and the Australian constitutions are concerned, because there the freedom of religion is virtually limitless and unrestricted. And it is the language of the constitutional provision is an injunction against the state. Congress shall make no law. And likewise in Australia, Commonwealth shall make no law, which will offend the freedom of religion. Whereas here we have Article 25(1) starts with a restrictive clause, which is subject to.
And 25(2).
And 25(2). 25(1).
Give the power to the state.
That's right, my lords. I'm grateful. So, my lords, the next point that I'd like to invite your lordship's kind attention to is page 14. Para 17, I needn't read because that is the provision of the Australian Constitution. And my lords, para 18 is a very pertinent point in respect of the present dispute. Kindly permit me to place that. para 18, as
Yes,
submitted above.
you have said in Turkey, the
Secular country.
Well, it's
which is a Muslim country. No, which is a secular country, but has a majority population of Muslim, wearing of hijab generally has been prohibited.
Please mark this, in a state-funded religious school. In a state-funded religious school, wearing of hijab has been, and that was right up to European Court of Human Rights, and that was tested on the anvil of Article 9 of the Convention, and the European Court of Human Rights has upheld the prohibition on wearing of hijab. And kindly see the last portion of that paragraph. When the girls attend classes in Quran, they may be permitted to wear hijab. Let's, in the present case, we are dealing with secular education, a public institution. Therefore, let's, in institutions imparting religious instructions, different considerations may apply. And let's, in para 19, I have dealt with the position generally in Europe. And before that, may I give your lordships only the relevant pages from that judgment in Kose. That judgment is Annexure 11 to the writ petition, and that starts at page 129. A judgment that arose from Turkey, judgment of the European Court of Human Rights. Well, these judgments of the European Court of Human Rights are in French, and the translation is provided. So we have produced the translation at 129, my lords.
Has been right from the day one saying that when Malaysian court judgment was referred, why at all we should travel that far? May not be, but anyway, this will throw some light which we will go through.
I am only placing this for this limited proposition, my lords, that even in a constitutional setup where only citing this, if your lordships want, I will give the relevant pages. I will not read them. Page
all right, we don't need it. We will go through it.
That's right, my lords. The next thing that I wanted to point out to your lordship's kind consideration is Annexure 10, which is a comprehensive research article by two academicians on the approach of the European Court of Human Rights from various jurisdictions in Europe. Again, my lords, we are not relying on those cases as precedents here, but since your lordships are taking a holistic approach and interpreting our constitution, Ano Bhadra Kritavo Yantu Vishwataha, let noble thoughts come to us from all sides. That is the only purpose for which I am inviting your lordships' kind attention to this. And this, my lord, this article, which starts at page 111, has two parts. The first is religion in education. We are not concerned with that. Please go to page 120, second part of the article, display of religious symbols in educational institutions. At 121, your lordships will see how various jurisdictions have dealt with this issue and how ultimately on an international platform, the European Court of Human Rights has resolved the issue and upheld the actions of the respective states. Those are my respectful submissions, my lords. I'm grateful.
Thank you. Thank you. Yes.
Yeah, please, Melot. Melot, I seem to be the last batsman, Melot, on this side of the. So I'll be brief, Melot. I have made a brief written submission. My colleague, Melot, Mr. Sriraj Gowda or Vishwas, Melot, will not consider. Melot, I've truncated this written submission, Melot, only to those aspects that have not been covered because rest of it, Melot, my esteemed predecessors have taken your lordships through. My lords, may I, before your lordships looks at, my lords, a few pages of this written submission. I also, my lords, have a compilation of decisions which I have put, but I will not trouble your lordships to go otherwise. Lords, would your lordships give me the permission, my lords, to pitch this a little differently at my lords threshold? I represent, my lords, respondents number 15 and 16. I'm, my lords, the chair, president of the College Development Committee and the vice president. First submission is I adopt everything that my esteemed predecessor, my senior Mr. Naganand has submitted in terms of the authority, etc. I'm not even getting into it. But one question fell from my lords in the early part of the that, and one of the petitioners was that there is some large scale outsourcing of this authority of the school to some political entity. And therefore, my lords, the question was brought up saying, why is an MLA sitting here? Lords, I must demystify. The circular of the government, which is issued, my lords, in 2014, which has not been challenged, and series of government orders which have not been challenged, did not outsource any educational function to a politician. What it did was organized educational institutions which are funded by the state. And this, my lords, the responsible institution here is a PU college for women, exclusively funded by the government. It is a government PU college, which is a common institution, high school and the college. A committee, therefore, was constituted to ensure imparting education and the well-being of that institution is looked at in tune with the local requirements rather than having one particular state-related formula for the entire state. Therefore, my lords, the committee only is presided over by the MLA, and that MLA may or may not belong to the political dispensation which is in power during that time. For example, my lords, in itself, we have had MLAs who have chaired, my lords, the College Development Committee across political lines. It has not been, my lords, the bedrock of any one political party. And as Mr. Naganand rightly said, when an MLA sits here as the president, he does not sit here as, my lords, a member of any party. Number one. Number two, there are bylaws constituted by this committee itself, my lords, in terms of how the committee will function, and I have put that, my lords, as part of my statement of objection. Lords, kindly see, apart from the president, there is a vice president who is nominated, who is either the municipal president for the area or a local leader, my lords, of some standing who is nominated. Now, barring these, the other members are 4 members from the parent community, out of which there is representation to the SC/ST community, 1 person from an educational enterprise, 2 student representatives. If it is a co-ed education, 1 necessarily should be a girl. In this, both will be girls because we are a girls' institution. The vice principal of the college, a senior lecturer of the college, and if we are a composite institution with the high school, a senior teacher of the high school, and the member secretary for this committee will be the principal of the college. Therefore, my lords, this institution has not been challenged, and a question came up. My lords pointed out saying, how is this MLA there? I am not there because, my lords, I am the MLA. I am there because the local requirements of what the institution should or should not have in terms of governance is taken care of by a committee that has plurality within it. Number one. Number two, my lords, there are, I will not trouble your lordships with series of wild allegations of defendant numbers 15 and 16, saying that they are sitting there without authority and therefore a quo warranto must be issued in the absence of challenging any one of these circulars and guidelines. Therefore, I will let it be, my lords. I will not distract that. But
whether this relief of quo warranto can be granted?
How can it be? It is, my lords, it seems to be that an overnight attempt at drafting a petition, and with utmost respect, a petition consists of rhetoric more than, my lords, please for your lordships. My lords, in that light, when I pitch, my lords, my submission before your lordships a little different. A case was made up of 1A rights before your lordships. A case was attempted to be made up of a 25 right before your lordships. And a case was also attempted to be made out of privacy of the individual before your lordships. Now, on all of these aspects, there have been answers that the respondents have been brought in. But my lords, my submission is the following. When your lordship looks at 25.2, and I will pointedly come to that exercise of whether 25.2 can trounce 25.1, but keeping that aside for a minute, when your lordships considers the rights enshrined under 25 and the rights enshrined under 19, two differences must be drawn out. A right to actually wear a particular attire in general connotation may be a right which will be culled out under Article 19.1 itself as an expression. A right to wear a religious attire or a particular religious symbol on a human body is a right which is amenable to Article 25 and not 19.1a, and that, my lords, has been laid down by Puttaswamy. I will read that paragraph of Puttaswamy. Therefore, a manifest of a religious understanding of an individual in the form of an attire of an individual is not a 19.1a right at all. It is actually a 25 right. And, my lords, 25.2 can bring in, of course, with all the proportionalities, my lords, as the Constitution will impose, bring in restrictions on the manifestation of that right. My lords, that should be looked at in the light of two articles. Of course, my lords, Article 51A has been read to your lordships, but kindly, my lords, permit me to point this out, and please make a note, my lords. 51A, subclause E, subclause H, and subclause J. I will very quickly read it and juxtapose it, my lords, to 39F.
Duties.
My lords, please, 51E. To promote harmony and the spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sexual diversities, and to renounce practices derogatory to the dignity of women. H. To develop scientific temperament, humanism, and the spirit of inquiry and reform. I am a school. J. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly raises to higher levels of endeavor and achievement. My lords, please juxtapose 39F for 1 minute. My lords, 39, interestingly, was brought in by the 42nd Amendment. The very amendment amplified the word secularism in our preamble, although it always that amplification occurred. Now, kindly see what that 42nd Amendment does in 39F. The state shall implement policy towards securing that children are given opportunities and facilities to develop in a healthy manner and in absence of freedom and dignity, and that childhood and youth are protected against exploitation, against moral and material abandonment. Kindly, my lords, see the manner in conditions of freedom and dignity. My lords, I hope I am audible. Just got information that there is some echo, my lords. I will be a little slow. My lords, in this slide, the proposition that I am placing for your lordship there is the following. Generally speaking, a manifestation of an individual's belief in a particular religion under 25.1. 25.1, rightly so, my lords, uses the freedom of conscience, and that is, my lords, I read that 25.1, subject to public order, morality, and health, and to other provisions of this part, all persons are equally entitled to the freedom of conscience and the right to profess, practice, and propagate religion. My lords, this distinction of freedom of conscience and professing, practicing, and propagating religion, my lords, is no more recent. Honorable Supreme Court, my lords, has two decisions, my lords, culled this difference. I will read those two paragraphs. But, my lords, may I wordsmith it differently? The freedom of conscience, my lords, is forum internum. For a person to, my lords, consciously decide whether he or she should follow a particular religion, should not follow a particular religion, be an agnostic, be a theist, be an atheist. No problem. That is, my lords, the freedom of conscience. That freedom, my lords, is absolute. The state cannot, my lords, in the process of its secular activity, dictate to an individual what he or she must decide conscientiously. However, practice, propagate religion is, my lords, forum externum. Once I have consciously decided that I will adopt a particular faith, how I manifest that faith in terms of my practice or in terms of professing it or propagating it to the world at large is forum externum. That forum externum is qualified under 25(2). And there is no doubt the constitution after, my lords, the rendition in Sabarimala, etc. And I will come to that. Therefore, my lords, under 25(2), there is nothing which prevents the state to bring in, my lords, restrictions in the economic, financial, political, or other secular activities. Kindly note that, my lords. I am at 25. Nothing in this article shall affect the operation of the existing law or prevent the state from making any other law regulating or restricting any economic, financial, political. Please ignore economic, financial, political for a minute. Or other secular activities of the state which may be associated with religious practice. My lords, I now take an example. I am a practitioner. I have consciously decided, my lords, to adopt the Islamic faith, and I am, my lords, practicing that faith. The right for me to be a Muslim, the state cannot ask me why. That is an absolute right. However, in the manifestation of that, if I turn up and say I have to therefore wear a particular attire to school, to college, to court, as a practicing Hindu, if I were to insist on wearing a particular attire because my community believes that that is the attire and intrinsic to my practice, to court or to my school, the question is that religious activity or is it a religious activity predominantly intruding into a secular activity? Education, my lords, in this country, and particularly education which is being imparted as public instructions with the aid or financial support, is purely, my lords, a secular activity. Article 28(1), my lords, clearly mandates that when it comes to, my lords, a secular activity of the state, religion will have no place. Kindly see, my lords, 28. Freedom as to at religious institutions or religious worship in certain education institutions. I read this, my lords, very slowly. No religious instruction shall be provided in any educational institutions wholly maintained out of the state funds. My lords, please ignore the etc., etc. Now the question I ask myself, my lords, is a sequitur to 28(1). If the state, an educational institution such as the Girls PU College here, cannot impart any religious education at all, that has been read also to mean that there can be no religious manifestations in that institution. In other words, no citizen who is, my lords, getting public instructions in the state can insist that he or she will wear and necessarily has to wear a religious attire to that institution, even assuming they build a case on essential religious practice. With utmost respect, my lords, the petitioners have miserably failed in maintaining a pedestal of religious practice with the hijab. In para 54, my lords, of Shaira Banu, Lordship Nariman, my lords, calls out how that religious practice should be determined by the court. I will come to that immediately. Now, even arguendo, it is an essential religious practice. It necessarily will have to yield in an educational institutions within the precincts of an educational institution. Therefore, a child may wear hijab based on the parents indicated to the child outside of the institution. But when they attend public instruction in the institution, my lords, two reasons: cohesion, brotherhood, and secular education being imparted in the institution is paramount, and it cannot be trounced by religious symbols being indicated. My lords, your lordships, Justice and my Lord Justice Dikshit also, my lords, indicated when there was Turkey decisions, etc., brought in, and an answer given by the petitioner is we are positive secularism. There it may be negative secularism. Positive secularism, my lords, unfortunately has been misread and misquoted by the petitioners. Positive secularism, as my lords brought down in S.R. Bommai, and I will read 3 paragraphs of it, clearly indicates that the state should do everything within its power to eradicate from the field of a public instruction, for example, or a secular activity, for example, any interference with religion at all. In that light, my lords, let me make this submission. We are looking at, my lords, building an institution in the state which is, my lords, of secular character. We have a law, unlike Vijay Emmanuel. Your lordships asked what is the ratio in Vijay Emmanuel. I'll come to that. Unlike the case of Vijay Emmanuel, where there was no law requiring a protected activity to be done. And therefore, it was not that the law was imposing certain restrictions on an Article 19 right, or a 21 right, or a 25 right. Therefore, my lords, the Honorable Supreme Court, the ratio of Bijoy Emmanuel is what? Not that somebody can stand and not sing. That is not the ratio. The ratio of Bijoy Emmanuel, unless you have a law, there cannot be any restrictions imposed on a fundamental right. It can only be by a law. And their lordships found in Bijoy Emmanuel that there was a circular which was issued, but that circular did not have the backing of a law. And therefore, they held asking them to do certain things. So long as they are respectfully standing, they need not sing. Bijoy Emmanuel is not a manifestation of a legal authority to say that because I have an Article 25 right, the state cannot do anything about it, because my essential religious practice is that I will not sing in favor of anybody else other than my own God. The state can do nothing. The state cannot bring law in the broadest terms, to impose certain discipline in a particular institution. Not at all. Therefore, please ignore Bijoy Emmanuel from the reckoning and the discourse, my lords, for the purposes of determining this matter. In the present matter, the Karnataka Education Act of 1983. The preamble to the Karnataka Education of 1980 Act of 1983 clearly indicates this. And please permit me to read 2 lines of that preamble, my lords. I will not trouble your lordship to look at the act, but I will read it. I am reading 2 lines of the preamble. For improving standards, better organization of discipline and control of educational institutions in the state, with the view to fostering the harmonious development of mental and physical faculties of students and cultivating a scientific and secular outlook through education.
This was pointed out by learned Advocate General.
Please, my lords. Now, when I say secular outlook through education, my lords, then the situation is the institution in the present case has every legitimate aim to ensure that within the precincts of a school, secular outlook is maintained to the core. Different communities are not distinguished by the attire they wear or the appearances they keep. My lords, the world is moving towards a uniform, not just in terms of a color, etc. A uniform, my lords, which is gender neutral. We are reaching a stage where we say, why should our girls wear skirts and our boys wear trousers? Why are we even making that distinction between our sons and daughters? That our sons and daughters must have education which empowers our daughters to believe that they are no less than from our sons. And therefore, they must have gender neutral uniform. Schools in Kerala, my lords, have brought in gender neutral uniform, that everybody will wear trousers. There will be no skirts for girls and trousers for boys. But here is a case where out of the 900 and odd children that are studying in my school, my lords, between, and my lords, for a minute, and I have pleaded this in my affidavit, I will, my lords, mention this. I have 956 children, my lords, in the school. Between PUC, about 600, and high school, about 350, 340. Out of these 956 children, 100 children are, my lords, belonging to the Muslim faith. Others, my lords, belong to the other faiths. Out of these 100 Muslim children, my lords, nobody till December, my lords, ever insisted on wearing hijab into school. 5 children, my lords, December, your lordships have seen the sequence, insist that now I will wear a hijab. 3 questions emanate. 1. Should the school therefore say under 25 you have a right to wear a hijab and therefore I will let you? Even assuming there is a 25 right, I will demonstrate there is no such right. Answer, my lords, is no, because school will ensure that I have cohesiveness and uniformity in my uniform. If anybody does not like that uniform, they are free, my lords, to find other institutions. This Udupi district alone, as an constituency, has 12 government colleges, not one. And it has multiple of private. A child can choose to go to an institution in which there is no uniform requirement in terms of not wearing a hijab or not wearing a saffron shawl. It applies to equal force, my lords, to a Hindu or a Muslim child. I don't want to, my lords, point to a particular community. My lords, in that light, I maintain cohesiveness and, my lords, ensure that there is secular outlook. Number 2, my lords, I will read decisions, my lords, from comparative law to place before your lordships. It is also the duty of a school. My lords, most of these children are minors. 8th, 9th, 10th standard minors, 11th and 12th standard, which otherwise in CBSE would have been a school, but in the state, my lords, it becomes a composite college in terms of a pre-university college. Most of them are minors. Therefore, my lords, the decision after they become majors to decide whether they will or will not profess a particular religion with vigor is left to them. But when they are minors, I have an obligation as a school to ensure that I provide the best benchmark to every girl child studying in my school so that she is not shackled by a particular restriction that is imposed upon her or a demarcation that is made upon her to say, you necessarily will wear hijab. And that is a duty as a school because I have to, my lords, organize my school on secular lines and ensure, my lords, that I achieve this secularism enshrined in the constitution through the mode of education. Therefore, the mandate saying cultivate scientific and secular outlook to education. My lords, in this light, please permit me to come to my note and read 4 paragraphs of S.R. Bommai. This question came up for consideration from S.R. Bommai on can the state actually simply stand back and say Article 25. Where is my note?
Whether this institution is all girls school or co-education is there?
My lord, my lords, I am a all girls PU college, a government funded pre-university college, which is composite between high school and pre-university with all girls students. There was no problem whatsoever. Children believed and professed various faiths, but until they came to school, they, my lords, wore whatever attire. But when they came into school, the precincts, the premises of the school, those attires, my lords, were removed, and within the school, everybody was in uniform. I will, my lords, place photographs of all my public functions in my statement of objection. I will request the court officer, just, my lords, optically. I will request the court of.
We just want to know one thing, whether all these petitions which have been filed, all the petitioners, whether they are students of purely girls' schools or the schools in which both boys and girls study.
My lords, in the petition appearing 2146, I can say, my lords, as a matter of fact, that it is an all-girls college and all of them are students, my lords, in an all-girls institution. And all of them, my lords, did not insist on hijab till December when this, my lords, so-called dispute erupted. For the last 2 years, no questions asked by any one of these children.
All right, the petitioners will reply to this, whether they all are.
School, my lord.
In that light, may I, my lords, straight away request your lordships to come to, my lords, my note, and I will be brief, my lords, in reading just a few paragraphs of that note. My lords, I have bifurcated my title A, my lords, is on secularism. Please come to straight away to page 2, my lords. I'll not trouble your lordships with the rest of it. My lords, in Bommai, my lords, a 9-judge bench, this question came up in terms of, my lords, the issue of religious practices and secularism in the light of secularism being a basic structure. Please see, my lords, in page number 2, at the lower part, I'm quoting 2 paragraphs from, my lords, Justice Ramaswamy's opinion. Please permit me, my lords, to come to 178 in particular, at the bottom quadrant of the page. My lords, I have quoted parts of the paragraph, my lords, and therefore I have been truthful to, my lords, wherever I have quoted extracts. And therefore, my lords, statements are indicated. The democratic society realizes the folly of the vigor of religious practice and strong religious consciousness not only narrows the vision, but hampers the rule of law. Matters which are left personal to the individual and the secular part is taken charge by the state on grounds of public interest, order, and general welfare. Lords, please ignore the lines. Please come to my lords, the portion where your lordships will find the word government full stop. Further, there can be no democracy if anti-secular forces are allowed to work in dividing followers of different religious faith, flying at each other's throat. The secular government should negate the attempt and bring order in society. Religion, in the positive sense, is an active instrument to allow the citizen full development of his person, not merely in the physical and material, but in the non-material and non-secular life. Now, let's please come to 186. The Constitution therefore protects only the essential and integral practices of a religion. The religious practice is subject to the control of public order, morality, and health, which includes economic, financial, or other secular activities. I stop there, minutes. Imparting education through public instruction is a secular activity of the state. None of the petitioners here can say that they are attending a PU college, either studying commerce, or humanities, or science. It is not secular education. Therefore, my lords, the interplay between religion and that secular education should be kept to the minimum, and concept of religion on it should be negated. My lords, please come to 180 part, my lords. The last 4 lines, I am reading only the relevant portions, the last 4 lines in 186. After the word worship, question mark, ... I quote, in order to secure constitutional protection, the religious practices should not only be essential part, but should also be an integral part of the proponent's religion, but subject to state control. Otherwise, only secular practices, which are not essential or integral part of a religion, are apt to be quoted as religious forms and can make a claim of being treated as religious practices. My lords, please ignore the reference. Towards the second half of the page, your lordships will find, my lords, I have quoted para 304 from his lordship Justice Jeevan Reddy's opinion, my lords, where he spoke for himself and for Justice Agarwal as he then was. Please permit me to read, my lords, in 304 over to page 5. My lords, I will read only about 4 lines from top. Lords, your lordships will find a sentence, my lords, about 5 lines from top. A sentence starting, my lords, how are constitutional? I'm reading that. How are the constitutional, social justice, liberty, and belief of faith and worship, and the equality of status and opportunity to be attained unless the state eschews the religion, faith, or belief of a person from its consideration altogether while dealing with him, his rights, and his duties and his entitlement. Secularism is thus more than a passive attitude of religious tolerance. It is a positive concept of equal treatment of all religions. Therefore, my lords, the equality in terms of uniform doesn't matter if you are a Hindu, within Hindu, whether you are a Kodava, Brahmin, Bant, or whether Christian, you are Orthodox, Jacobite, Syrian Christian, or within Muslims, you are Sunni or Shia. Everybody has the same uniform. My lords, kindly see 3 immediately after that, my lords. In short, in the affairs of the state, which includes imparting education, in its widest connotation, religion is irrelevant. It is strictly a personal affair. Therefore, when I prescribe as an institution, religion for me is irrelevant. And I am entitled to do so because of Article 25.2. My lords, for 25.2, kindly see, we have a principal act, which is, my lords, a plenary legislation 83. We have Rule 11, my lords, which are made, my lords, as subordinate legislation under the 1983 Act. Rule 11 empowers every institution to have its own uniform. I ask my question why? Rightly so, because the state can't have one uniform across the state. Region specific, my lords, nuances require different uniforms for different regions. And therefore, my lords, power to impose a uniform in the academic rigors of a school, my lords, is made out by law. Nobody challenges that. But the challenge is actually having a law, which is a law, my lords, under 25.2, and I'll come to public order. You are eschewing or you are imposing restrictions on my right under 25.1. My lords, again on public order, after Sabrimala, that issue is no more acceptable. His Lordship Nariman, my lords, in the opinion in Sabrimala indicates that public order includes and tranquility. My lords, maintaining cohesiveness in school is a matter of tranquility. Maintaining cohesiveness in, my lords, the community is a matter of tranquility. Therefore, my lords, imposing a uniform in school essentially ensures that secular education is imparted in the most peaceful and uniform manner. That is public order. If that is not public order, nothing else can be public order. Therefore, to indicate and say, no, this power is not public order. Law and order is a very small subset of public order. My lords, the last submission on before I move on. My lords, is paragraph 0 at page 5. I'm quoting 310 some aspect. The Constitution does not recognize, it does not permit mixing of religion and state power. Both must be kept apart, and that is the constitutional injunction. I could not have my lord provided for secular education, teaching physics, geography, and chemistry, and then indicating that everybody come in your religious attire, you're free to do so. That would erode into, my lords, the concept of secularism. So what is the petitioner asking for? Saying that please allow all religious dresses to be brought into school. It is no more secular education. My lords, secular education is not just academic discipline. Schooling is not just about academia. Schooling is about overall development of a child. And therefore, my lords, in that light, I will, my lords, go forward on the note. I'm conscious, my lords, that being the last, I have, my lords, restrictions in terms of time. My lords, please see paragraph 2. I am raising this 2026 SCC 899 Sheikh Mohammed Rafiq, my lords, only as an incidental matter. My lords, a question came up before the Honorable Supreme Court as late as 2020, where after TMA PI, etc., whether a minority educational institution will have complete freedom in terms of what they will do. The question was, and that if a minority institution which otherwise imparts religious education also as one or two subjects imparts general education such as arithmetic and English, when it comes to imparting that secular aspect within the religious institution, should they actually follow the master of the Constitution in terms of recruiting a particular teacher, in terms of merit, etc., or is it free actually to bring in another religious scholar? The Honorable Supreme Court held no. Even if you are a religious institution, you are given the protection of TMFI, etc. In the small aspects of secular activity, even within that religious institution, you will actually maintain and bring in equality. Well, as I go forward from there. My lords, I have on point B, my lords, I will not dilate. I have, my lords, already pointed out the provisions of the Constitution and, my lords, the preamble of the Act. My lords, I come to see. I am conscious that your lordships are not looking at comparative law from other jurisdictions. But I must dilate only one aspect in less than 2 minutes, and then I will go forward. My lords, I will not read the entirety of C to your lordships, but except to bring about one comparative analysis of what our Article 25 is and what Article 9 of the European Convention is. Please see, my lords, in page 8, at the footnote at the bottom of page 8. I have extracted Article 9. I'm just reading that, and I will say what happened in this case. My lords, Article 9 of the European Convention in 9.1 and 9.2 has all of this. It has the freedom of conscience included. It has the freedom, my lords, to profess religion, observe religion, and manifest religion, which is included. I read that, my lords. Everyone has the right of freedom of thought, conscience, and religion. This right includes the freedom to change his religion or belief, and the freedom either alone or in community with others, and in public or private, to manifest his religion or belief in the worship, teaching, and practices and observance. Therefore, forum externum right, as we have in Article 25, is in 9. Kindly see, my lords, 2. Freedom to manifest one's religion or belief shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society. I will come to that test of necessary in a democratic society as to what Supreme Court says, my lords. In the interest of public safety and for protection of public order. health and morals, or for the protection of the rights and freedom of others. My lords, effectively, Article 25(1) and Article 25(2) is Article 9, my lords, of the European Convention of Human Rights. My lords, in this light, would your lords, I seek my lord's indulgence. Would your lordships permit me, my lords, to read paragraph 10, 4 paragraphs that I have quoted. They are very instructive, my lords, and I can't wordsmith it better. My lords, para 10 of my note at page 8. This is, my lords, the case of Lebanon versus Turkey. A lot of Turkish decision, South African decision, everything is brought before your lordships. Okay, this happened and the other. Nobody looks at what is the analysis that the court did. My lords, in Laila scene, the question was, even in a higher education, a student wanted to wear a hijab. Turkey, my lords, although a Muslim majority country, is a secular democratic polity, and therefore, my lords, there was a restriction on wearing hijab even to a higher educational institution where a child is a major, child is no more a minor. In that case, my lords, the question came up, and I read, my lords, para 10 of my note. I am reading, my lords, from internal pay, para 30. Please permit me very quickly to read these 4 paragraphs, and I will go forward. In their judgment, the constitutional judges explained firstly that secularism had acquired constitutional status by reason of historical experience of the country and the particularities of Islam compared to other religions. Secularism was an essential condition of democracy and acted as a guarantor of freedom of religion and equality before the law. It also prevented the state from showing the preference for a religion or belief. Consequently, a secular state could not invoke religious conviction when performing its legislative function. Stressing its involuntary nature, the Constitutional Court observed that freedom of religion, conscience, and worship, which could not be likened to a right to wear any particular religious attire, governed first and foremost the liberty to decide whether or not follow a religion. Article 25, the freedom of conscience, is the right to follow a religion. It is not a right to manifest it by wearing a particular attire. I'll go forward, Millet. To explain that. Once outside the sphere of individual conscience, freedom to manifest one's religion could be restricted on public order grounds to defend the principle of secularism. Everyone was free to dress how he or she wished, as a social and religious value and traditions of a society also had to be respected. However, when a particular dress code was imposed on an individual by reference to a religion, the religion concerned was perceived and presented as a set of values that were incompatible with those of contemporary society. In addition, in Turkey, where the majority of the population are Muslims, presenting the wearing of an Islamic headscarf as a mandatory religious duty would result in discrimination between practicing Muslims, non-practicing Muslims, and non-believers on the ground of dress, with anyone who refused to wear the headscarf undoubtedly being regarded as opposed to the religion or as irregular or as irreligious. My lords, I stop here for a minute. I have 100 Muslim children, my lords, in my school. 8 of them have my lordship saying, I want to wear a hijab. If I were to truncate my uniform and say that, all right, you wear a hijab, the remaining 95 Muslim children are now what my lords led to say what? That they are irreligious. And the only girls who are wearing hijab are therefore religious. This is independent of the not an essential religious practice. If an institution were to allow, let us say, any religious symbol, those people who don't carry the religious symbol are considered irreligious within the community. Then where is cohesion, my lords? Where is public order, my lords? Bringing in discipline and cohesion in school is the first step towards public order in society. My lords, I go
to that, Mr. Povaiya, to that extent, you sail with the learned Advocate General.
Absolutely, my lords. It is, in fact, my lords, my primary duty as a school to mention, and irrespective of what the state does, state may or may not prescribe a uniform. It is my primary duty to make sure, my lords, that I have a uniform which will rid itself of all religious attire. And therefore, my lords, the wording of Ramaswamy Justice in, my lords, the first paragraph, that the state should actually, my lords, effectively ensure that religion is forcefully kept out of a secular discourse. I need to do the positive, not just tolerate it. My lords, I go forward. Please permit me to read, my lord, the last paragraph in para 9, page 9. A constitutional court ordered that a student had to be able to work and pursue their education together in a calm, tolerant, and mutually supportive atmosphere without being deflected from that goal by signs of religious affiliation. It found that irrespective of whether the Islamic headscarf was a precept of Islam, granting legal recognition to a religious symbol of the type in higher education institution was not compatible with the principle that state education must be neutral, as it would be liable to generate conflicts between students with differing religious convictions and beliefs. That is, my lords, Article 21 of our Constitution. When we say no religion, my lords, teaching the Quran or the Vedas or the Bible, that is, my lords, a very simplistic way of looking at 28.1. 28.1 also necessarily then mandates that the state eschews all religious affiliations, my lords, or religious manifestations in an educational institution which imparts secular education. My lords, I now with this come to my lord, the test of necessary in a democracy. Kindly turn, my lords. This necessary in a democracy, my lords, is an indication as to seeing whether I need to control religious manifestation, not the freedom of conscience. Everybody can practice any religion. But should I control the manifestation of religion or manifestation of religious symbols or attire when it comes to secular activities in life? My lords, a lady or a man can wear a religious attire when he goes to pray or she goes to pray. No problem about it. They can wear the religious attire when they are performing religious functions. No problem about it. As Mr. Naganand rightly said, when a puja is going on, my lords, they will actually not have a cloth which is stitched. They will have an angabastram. But when that same gentleman or lady comes into the domain of a secular activity, whether it is education, whether it is practicing in a court of law, whether it is going to an office, whether private or publicly governed, that secular activity, you can't bring their religious manifestations to bear. And that is, my lords, what Sabrimala says as well, my lords, and I will read those 3 paragraphs in Sabrimala towards the end, my lords. Now, in this light, my lords, what is the doctrine of necessity in a democratic society? My lords, please read the 4th section. No, there's some.
All right, all right. So,
I think I'm sorry, my lord. Your lordship.
no, no,
We are hearing you.
you are audible. There's no difficulty.
My lords, I to be. The 4th section of the European Court of Human Rights, that is, my lords, in violation, applied the question assessing whether there was a violation of Article 9 in our Constitution which has taken. The court must consider the applicant under Article 9 was interfered with, and if so, such interference prescribed by law pursuant to and was necessary in a democratic society within the meaning of Article 9. My lord, this necessary in a democratic society is not a concept to our belief. My lords, please consider in Puttas judgment, but this issue of necessary in a democratic society was, my lords, brought in, and I read that paragraph 12. The Supreme Court 2009 SEC 1 has adopted a similar test when adjudicating upon the actions alleged to be in violations of the right to privacy, that is the right to permanent property of the Constitution. My lords, in paragraph Justice Palameshwar says so. As noted, whenever a state on the ground that it violates the right to privacy, the action of the following paragraph: A must be sanctioned. B, action must be necessary for a legitimate, and C, the extent of interference is proportional. My lord, this necessary in democratic society, I will end dovetails Act, which says scientific and secular outlook will be incorporated to education. Therefore, my lord, necessity in a democratic society mandate is that it is necessary for maintain the secular character of all public institutions. Malats, I go. Malats, please paragraph 87, 99. The Turkey. And Malats, I will to a sentence. Malats, please. Para 13, internal paragraph. In a democracy in which several religions coexist in one and the same population, it may be necessary to take restrictions on freedom to manifest one's religion or belief in order to reconcile the interests of various groups and to ensure that everyone's beliefs are respected. Now, that's 90. Please permit me to. In Kardinal and Dalab, I go forward. Institutions found that in a democratic society, the state was entitled to the wearing of an equipment. If it was pursued protecting the rights of public order and public safety. In Dalab, in which an athlete was in charge of a children. It stressed among other matters the impact that the external symbol conveyed by her wearing could have whether it could have some kind of proselytizing effect, meaning that it could be imposed on women by a pleasant breakdown in Quran that was hard to reconcile with the principle of gender equality. Well, with the hope that Nana can be better at in 1 minute. Exactly 1 second. Well, it's possibly this may be better, man. Well, I go for like that the principle is undoubtedly one of the fundamental principles of society, which are in harmony with the rule of law and respect for human rights. In that context, particular universities may regulate the administration of the rights and symbols of the said society by imposing restrictions as to the place and manner of such manifestation with the aim of coexistence with students of various and thus protecting public. It all doubted. Well, with this decision away, I am going forward. I have indicated in the next page. I have indicated rule 11. I will not touch upon rule 11. May I other aspects? That is, at para. This is a question. Your lordships. And my lords to practice and profess my lords religion. My lords, in that one paragraph, my lords, I read. This is my lords in European, the Court of Justice of the European Union. I'm just reading that paragraph just to complete this, my lords. I will not read the recitation. Recently, the Court of Justice in Webb and Mueller handled in 2021 July dealt with the question on whether an internal rule of a private undertaking prohibiting workers from wearing any visible sign of political, philosophical, or religious belief in the workplace constitutes to the workers who observe certain clothing rules based on religious custom, a direct or indirect discrimination on the ground of religion or belief. It also referred to the concept of forum internum, that is the fact of having a belief, and forum externum, that is the manifestation of religious belief in public. Malats, I will not read its entirety, but 52 Malats kindly sees about 4 or 5 lines down, Malats. After the meaning of Article 2A of the directive, the court has already held that it does not constitute discrimination of that sort, provided that it covers any manifestation of such belief without distinction and treats all workers of the undertaking in the same way by requiring them in a general and undifferentiated way inter alia to dress neutrally, which precludes the wearing of such signs. Therefore, I cannot permit a Hindu child to wear, my lords, a religious symbol, but not permit a Muslim child not to wear a religious symbol. Therefore, it is not a case, my lords, because a Muslim child is wearing a hijab, there is a Hindu child telling me today that he or she will wear a saffron scarf. Where is the end to it, my lords? Both of it, my lords, this negative equality situation can't come in. My lords, with this, I go straight away, my lords, to just two paragraphs in page number 16, paragraph number E. My lords, I will not read. Please come straight away, my lords, to page 16, essential religious practice. Please come to page 17, my lords. I have quoted in paragraph 21 of my note. I have quoted, my lords, paragraph 122 and 124 of, my lords, the opinion of Justice Deepak Mishra, who, my lords, for himself and Justice Kanvilkar in Sabarimala. May I, my lords, read that one line there and straight away go to, my lords, two paragraphs in Justice Nariman's opinion, and I'll stop at that. Let's kindly see what Justice Deepak Mishra at 122 says in Sabarimala. In the light of the above authorities, it has to be determined whether the practice of exposing women in the age of 10 to 50 is equivalent to the doctrine of a Hindu religion, or that a practice that should be regarded as essential part of a Hindu religion, and whether the nature of Hindu religion would be altered without such explicit practice. My lords, I come down to the wording, my lords, which says prayers and deity, and the last three lines in that para. In the absence of any spiritual or textual evidence, we cannot accord to the exclusionary practice followed at the Sabarimala temple the status of an essential practice of Hindu religion. My lords, please turn over leaf. Please come straight away, my lords, to the opinion, which is, my lords, the opinion of Justice Nariman at page 18, para 176.6. My lords, in that 176.6, please permit me to read, my lords, about 10 lines very quickly. It is only the essential parts of a religion as distinguished from secular activities that is the subject matter of the fundamental right. Superstitious belief which are extraneous and unnecessary accretions to the religion cannot be considered as essential parts of the religion. Matters that are essential to religious faith and or the belief are to be judged on the evidence before a court of law by what the community professing the religion itself has to say as to the essentiality of the belief. One test evolved would be to remove the particular belief stated to be an essential belief from the religion. Would the religion remain the same or would it be altered? Equally, different groups of religious communities speak with different voices on the essentiality aspects presented before court. The court is then to decide as to whether such activity is or is not essential. Religious activities may also be mixed up with secular activities, in which case the dominant nature of the activity test is to be applied. I stop there, man. If we say that a child who wears a hijab is prevented to wear a hijab into school, question is, would it alter the religion or would the religion remain the same? The sequitur is this. Does this mean that all the other 95% of the Muslim children who are not wearing hijab to a school, they are not professors or practitioners of Islam? Has the essence of Islam changed by a lady wearing or not wearing hijab? Akin to Hindu faith, my lords. If I don't actually wear, my lords, a tilak, or if I don't wear, my lords, a saffron attire when I go to pray, if I go to a temple, my lords, in a denim jeans and a t-shirt to pray, is the essence of Hindu religion lost? My conscience is, I will be a Hindu, I profess Hindu faith. But my attire, my lords, is just a manifestation. Please come to 285, my lord. Next para is of utmost importance. And my lord, this 285 is Justice Chandrachud's opinion, my lord. And I read that, my lord. It went through an editorial correction. I put that as well and I read it. My lord, 285. In this jurisprudence of religious freedom, this court has evolved a body of principles which define the freedom of religion under Article 25 and 26 to practice, quote unquote, essential to religion. The Constitution has to protect not only freedom of religious belief, but acts done in pursuance of those beliefs. While the views of religious denominations are to be taken into consideration in determining whether a practice is essential, those views are not determinative in its essentiality. Kindly note that. The court has a central role in determining what is or what is not essential to religious belief. Intrinsic to the role which the court has carved out, it has sought to distinguish between what is religious and what is secular practice, even if it is associated with religious activity. Going further, the court has inquired into whether a practice is essential to religion. Essentiality of a practice would, as the court has held, depend on whether the fundamental character of a religion would be altered if it were not observed. Above all, emphasis on constitutional legitimacy. Kindly note this, Millets. Above all, there is an emphasis on constitutional legitimacy, which underscores the need to preserve the basic constitutional values associated with the dignity of the individual. Millets, I stop there. The basic constitutional value for me as a school is I have to impart secular education in my school. I have to, my lords, under 39J, ensure that dignity of the girl child is protected. I will not, my lords, prescribe a protective attire to a girl child and no protective attire to a boy child. Why? On the religious faith, to saying that girl must dress modestly and a boy need. My lords, for a minute, please permit me to dilate on this. When religion, my lords, was formed and these embodiments came in, my lords, in our holy texts, whether it is the Quran, whether it is the Bible, or, my lords, the Hindu religious texts, that was a time when society, my lords, might have had certain requirements to maintain community standards. Maybe at that point of time, women had to wear a particular attire for maintaining, my lords, community standards. That is, that you protect yourself from the gaze of a man, etc., etc. May have been, I don't know, I'm no expert on it. However, today, my lords, community standards are not maintained by our religious texts. Today, in a democratic polity that is India, community standards is maintained by the rule of law. If a man actually misbehaves with a woman, he should be prosecuted under the law. When the rule of law maintains community standards in a secular democratic polity, the question then I ask myself is, what is the need to have a protective attire for a female on the basis that a female should be protected from the gaze of a man and the female must dress modestly? My lords, I again ask myself the question, why is that we teach our girl child to dress modestly and not our boy child to dress modestly? Are our girls educated than our boys? Is that what the Constitution, my lords, imposes upon us to build a society? Therefore, my lords, as a school, I have the obligation to ensure that I gradually go towards a gender neutral uniform. Not even to say salwar kameez for girls and pant and shirt for boys. Certainly not to say that girls must therefore protect themselves with a headgear. In that light, I have an obligation, my lords, an argument was raised before your lordships, my lords, in the connected petition by my esteemed friend, Mr. Kamath. Once it is a matter of faith, nobody should go into it. It is the person's faith that should be protected. Your lordships also should not go into it to take a decision on whether it is essential or not essential. With utmost respect, the law is marched. My lords, after pre-Shirur Mat, my lords, whatever may have been the law, after Shirur Mat, after Venkataramana Devaru, after Saifuddin Saiba, my lords, that is the Mori Muslim excommunication case, and my lords, now Shabrimala, the law is, court is central to taking a decision that it is essential or not essential. It is not left, my lords, to the private person. And that can be done only by evidence that is being brought in court. If my learned friends had filed a civil suit, my lords, and brought in evidence, it's a different matter. No, not even a single affidavit, my lords, brought in to indicate whether it is essential or not essential, except to quote, my lords, one or two paragraphs of the Quran. Therefore, my lords, the fact that burden is, my lords, not discharged. Kindly see, my lord, the last three lines, my lords, of Justice Chandrachud's opinion at 285. Apart to, my lords, character of a religion, etc., fundamental character of religion being altered, they say above all, constitutional legitimacy is the question. In a constitutional legitimacy situation, can we dress our girls differently to say, no, you have to dress modestly? Where is this concept of modesty for a girl child coming from when there is no school uniform of modesty for a boy child? Well, in that light, I'm conscious that I have gone beyond 345. Would your lordships give me 1 minute, my lords, on the justification? Please come to page 20, my lords. My lords, in page 20, please come to, my lords, page 20, para 23. Free speech consideration. I will not read it, but please, my lords, note 373 of Puttaswamy. In 373 of Puttaswamy, the question came up on, will religious appearances be a part of personal autonomy and therefore 1A and a 21 right as right to privacy? That was also pitched before your lordships. I have personal autonomy. I should be allowed to wear what I should. My lords, in 373, their lordships say, the choice of appearance and apparel also aspects of the right to privacy. But continue, please continue. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping of long hair and wearing a turban, in this case, hijab, are protected not as part of a right to privacy, but as part of their religious belief. Therefore, this protection applies to them under 1, which is subject to 25(2). And therefore, my lords, we can us by saying everything is put under 19, everything is put under 21. Freedom of conscience is also 21, my lords. How can I be a full-fledged individual and not have a right to life if I don't have a freedom of conscience? But freedom of conscience is 25. It is subject to other parts of Part 3. It is subject to 25(2), which is subject to, my lords, building an egalitarian, social, secular order in the country. And that is important. That's why I brought Bommai, saying maintaining a secular order is the paramount obligation, my lords, of the state, or for that matter, educational institution. And when it comes to education institution, I must be given the latitude, my lords, to prescribe my uniform. My lords, last thing is G, my lords, at 21. This is, my lords, the justification pattern. My lords, Regina versus Denbigh was brought in, my lords, that is the House of Lords decision. I will not read it, but I will only trouble your lordships, which are kindly see the question, my lords, which Baroness Hale brings out is this. My lords, in para 96, Baroness Hale brings out. May I, my lords, would your lordships permit me in 3 minutes, my lords, read 96, 97, and I stop. My lords, kindly see what Baroness Hale says in Regina after looking at the modicum of entire law and rights and freedom of religion. My lords, I read 96. 96 ostensibly is against it, but please see how it goes out. If a woman freely chooses to adopt a way of life for herself, it is not for others, including other women who have chosen differently, to criticize or prevent her. Yes, somebody can wear hijab, somebody can wear, my lords, the shortest of clothes, no problem. Judge so-and-so in Senegal versus Turkey draws an analogy with the freedom of speech. The European Court of Human Rights has never accepted that interference with the right or freedom of expression is justified by that the ideas expressed may offend someone. Correct. I can't say it offends me, therefore don't wear hijab. Likewise, the sight of a woman in full parda may offend some people, and especially those Western feminists who believe that it is a symbol of her oppression. But that could not be a good reason for prohibiting her from wearing it. Correctly so, it is her right to wear. But please see 97 minutes. But schools are different. Their task is to educate the young from all the many diverse families and communities in the country in accordance with the national curriculum. I have a state curriculum. This task is to help all of their pupils achieve their full potential. This includes growing up to play whatever part they choose to in society in which they are living. The school's task is to promote the ability of people of diverse races, religions, and cultures to live together in harmony. Fostering a sense of empathy and cohesion within the school is an important part of that. A uniform dress code can play its role in smoothing over ethnic and social divisions. But it does more than that. Like it or not, this is a society committed in principle and in law to equal freedom of men and women to choose how they will lead their lives within the law. Young girls from ethnic and cultural or religious minorities growing up here face a particularly difficult choice: how far to adopt or to distance themselves from the dominant culture. A good school will enable and support them. Stop there, Melody. A good school has to support a girl child to say, I don't want to wear it. For which I have to first make sure that I instill constitutional values in them until they become a major, and then take a decision for themselves on whether they want to wear a particular attire or not. My lords, in that light, the last paragraph, my lords, I'm not reading, my lords, 98 and 99. I wish, my lords, I could have read the in para 26 to 50 as well, my lords. But kindly see para 27, my lords. In the light of the above, that allowing exceptions or exclusion to uniforms in the name of religious freedoms and non-discrimination is a self-defeating argument. Uniforms are mandated not with an intent to discriminate, but to prevent the very discrimination on the grounds of social, economic, and religious status. That's exactly what I need to do, my lords. To remove the discrimination, everybody wear the same thing. You may be rich, you may be poor, everybody wear the same uniform. You may be Hindu, Muslim, wear the same uniform. My lords, in that light, I will end my lords by introducing my lords para 54 of Shaira Banu. My lords, Shaira Banu is there in the Aegis compilation. In Shaira Banu, my lords, their lordships, my lord, when looking at whether this is actually a mandate in the Quran, etc., clearly, my lords, in 54 indicate there are multiple degrees of compliances that Quran indicates. Starting, my lords, from the fard, which is the first degree, to my lords, haram, which is the fifth degree. They say we can't be sitting down and saying that everything in the Quran is therefore essential religious practice. And if somebody wants to prove it, my lords, that evidence must be brought. But my submission, my lords, is one step more, and therefore I'm pitching it differently. Even assuming it is an essential religious practice, under Article 25(2), I am entitled as a school to ensure that no religion is compound. And it shall not, my lords, until my school runs as a secular institution, imparting public instructions, that too, my lords, with the aid and of the state. I am obligated, not just I have a higher order, I am obligated under the Constitution to ensure that no religious symbol enters my school compound. My lords, with that, my lords, I rest my case. I am very, very grateful for the patient hearing.
Thank you. Continue tomorrow. Represent whom? Who is respondent number 8?
Yaru. Respondent number 8. Who?
Who is respondent number 8?
Describe. Teacher, student, college. Huh?
What more is to be argued on behalf of the teachers? Mr.
And he requests only 15 minutes time. He has a very different point which has to be put before this not report. 15 minutes time is that we request for.
All right.
Need some time for rejoinder, my lords. We have heard very erudite, my lords, arguments. My learned friend, my lords, I need some time to rejoin, my lord. Tomorrow, my lord.
You will get your time.
Lords, after the rejoinder, my lords may consider interveners, my lords, only requesting. We can just get a few minutes, my lords.
I will request all the interveners to make your written submission and submit it to the court.
My lords may just give us 10 minutes. I won't take
No, we don't need any assistance of the interveners, but since so many of intervener applications have come, so we don't want to disappoint you all. We say that whatever you want to say it in writing, prepare your written submission and submit it, we will consider it.
The only reason I was mentioning, my lords, even the no one has made the argument of sex discrimination.
We cannot continue hearing this matter for 6 months.
Only 10 minutes, my lords. I'm
If
requesting
people want that, we will not have this bench every day.
Only a request, my lords. I leave it to my lords. 10 minutes if we get, I'll be...
Not possible. We have to dismantle the regular benches and then special benches to be constituted. And every day we are hearing these matters. So we want you all to be very brief in your submissions and finish your arguments as early as possible.
We have
Praises, my lord. I'm in student number 3.
killed in Karnataka named Harsha because
Who are you?
Right of rejoinder. 3038, my lord. I'm arguing for the petitioners, my lord.
Somebody else is making a mention, Mr. Yusuf. So,
I am moving this intervention because...
No, we are not hearing any intervention application. We have made it very clear from the beginning.
Kindly hear me for 30 seconds.
No, sorry, you cannot insist. You have no right to be heard unless we call upon you.
A man has been killed 2 days back because people do not understand whether it is a religious practice or not, whether it is an essential religious practice or not.
Go and initiate the criminal proceedings.
No, there is already going on, but then people are fighting on roads.
This is not the matter in which we have to consider all that.
In respect of 2 petition, Lordship, there is only we are seeking some clarification. There is a degree college student.
What can be done? You are seeing it. We are not getting any time to consider your application.
Several problems. No, Guru Lords. In fact, I must, if Lordships permit me, in both the petitions, my learned friend has filed, In fact, my learned friend himself has filed one more petition with reference to the same institution. The matter came up before the learned single. The learned single judge has already passed an order that the interim order passed by the full bench will also apply to all these institutions. Matter rests there. The question of not again coming up before your lordship with another student of the same institution is nothing but vexatious. Lordship, my humble submission is same count. Already order has been passed.
Your Lordship, please, my Lord.
That clarifies the position. Where is the question?
I make my submission, Lordship. I have already pointed out that aspect. Even that interim order also I presented. The order of this court very clearly stated that in para number 11, it is only confined to those schools that a CDC is there. But that is a degree college student, and this particular order does not apply. Even the interim order was passed. There is no clarity. For that reason, I moved this petition for seeking clarification of that order. That is only a limited prayer I am making. I have not kept anything in dark. I bought all the fractions because even I bought the
wait for your turn. Wait for your turn.
My humble submission, exams are going on, Lordship. There are two petitions are there. One is for degree college. One is a private PU college. If some clarification made, some problem will resolve, Lordship. Already department has called for the exams. They are not allowing them to go in. There is no uniform is there. Degree college students are suffering, Lordship. For that purpose, I am just. This is not a big.
The order is very clear. We have said that wherever the uniform are prescribed, they are to be followed.
Making general.
Where there is no uniform, there is no question of.
That's a difficulty, Lordship. What is citing this order? Every institutions are pushing the students outside the college, Lordship. Citing this order. For that reason, one clear word will be there from this honorable court. We have no disagreement from the order. We are saying just clarify this. I am a degree college student. Will this order apply on me or not? That is only when already during the course of argument, Learned AG has already submitted that in degree college there is no uniform is there. In spite of that, colleges are making this kind of.
I do not know what the learned friend is speaking, but I really because he has now filed a writ petition in respect of Bhandarkar College. He also filed a writ petition by in respect of another student of the same institution. The institution appeared before the single judge and said that they have passed a resolution prescribing a uniform.
Then, if the uniform is prescribed, then they have to follow it, whether it is a degree college or a pre-university college.
So far, there is no role of no uniform in any degree college. In these petitions, they came and they wanted to find. Lordship, these arrangements cannot be done immediately. They just one fine day, one institution comes and says that we are prescribing uniform, so this order will be applicable on us. The order is an interim arrangement, Lordship. Very clearly in para number 11, it is clearly been stated that even in the college itself, their rule book clearly prescribes that the girl student can wear headscarf.
How can we verify whether there is a
Lordship,
you will have to believe it on the college. Why college say that there is a uniform?
They are citing the order of this honorable court. This order, para number 11 is very clear. I am just asking clarification on that aspect. Because they are citing this order. Everywhere they are citing this order.
We have made it clear that wherever the uniform is prescribed, that is to be.
Kindly peruse para number 11. Lordship. Kindly peruse para number 11 of the order.
What do you want to show?
We make it clear that order is confined to such institution where the college development committee has prescribed the school dress code uniform.
Yes.
This is college development committee in respect to government PU colleges.
No.
There is only government PU college only
that was the petitioner's college.
All that I would submit, but if somebody has violated this order, but he has to bring it before your lordship, calling into question that order. This kind of allegation without any
some clarification will make
from the past clarification. If somebody has there are two private institutions.
We are making it very clear that wherever, whether it is a degree college or a government college, undergraduate, if the uniform has been prescribed,
yes,
then that has to be followed.
It is not there.
So long as the matter is pending before the court.
This is not there. This is not the instance of this order. Para number 11 clearly says that college development committee, and there was a discussion of the legality of the college development committee also.
This is what now you want clarification. We have made it clear.
It will create a choice in the society.
No,
because everybody is quoting this order and they are pressing their own rules, Lordship.
Yes, tomorrow too.
Lordship, please, my Lord, may I just say, Lordship indulgence, my Lord.
But some hearing is required.
We cannot hear so many people at a time.
But some hearing and these two petitions, this hearing is required.
The teachers are not only the teachers are forced to be remove their headscarf and forced to be remove their burqa and all after before entering the college.
Do it.
Teachers, we are
creating a discrimination in the society.
The order is
It's creating a discrimination in the
students.
society. I can say this.
The order confines to students only.
I would request for this kind of statements cannot be
All right, thank you very much.
This kind of explanation.
Tomorrow at 2:30, the arguments of Mr. Naganan, the Council for Respondent Social has concluded. Mr. Sajan Puria has also concluded his arguments along with Mr. Raghavan Srivas for respondent number so and so. It is informed that Council for respondent number 8 has to make his submissions put up tomorrow at 2:30.
Degree colleges. This order, my lords, this order will not apply to degree colleges. Degree colleges